The chairman calls the Senate Judiciary Committee back from recess and into order. If there's no objection, the chairman detects a quorum and we will dispense with calling the roll. Seeing no objection, we are ready to move on to the next bill on our calendar, which is by Senator Beavers. And that is Senate Bill 250. Senator Beavers, if you would please indulge me for a minute here. I think it's very helpful to give some historical context to this discussion. We discussed last week. We threw around a lot of names. We threw around the names of Jefferson, of Madison, and Jackson, and I think it's helpful to review our constitutional history, and it's very helpful to do that, and I appreciate that aspect of this bill, is that it has caused many of us to go back and to review our constitutional history. You know, I mean, of course, the Constitution was not the ruling law of the land after the Revolutionary War. It was the Articles of Confederation. Many folks felt that the Articles were not strong enough. It didn't have a strong enough federal government. Didn't have a judiciary or an executive at all. In fact, and in particular, you couldn't levy taxes under that. So the Constitutional Convention was called in 1787. It was actually called originally to amend the Articles, though it quickly went beyond that. Interestingly enough, Jefferson was not present for that Constitutional Convention. He was ambassador to France at the time. However, his protege Madison was there. Showed up earlier than other members, drafted the Virginia Plan, which became a large part of the ultimate document, especially after the Great Compromise. And that Constitution was drafted, and it was finished in 1787 in September, and it provided for a government of limited and enumerated powers. And that's what it provided. Interestingly enough, it actually went into effect under its own terms when only 9 of 13 states had ratified it, which was different from the Articles of Confederation, which had required unanimous support to be amended. So there was an interesting question of validity there. However, in my personal opinion, having Washington there to be the presider over that convention is what gave it its ultimate authority, in that Washington was so respected as not only a war hero, as someone who was quite frankly was charming and good looking, but also because ultimately of his character and the character that he showed. And so that's where we were to try to sell this to 9 of 13 states. It went fine on the ratification process through the first 5 states, and then ratification ran into trouble with Massachusetts. And there were obviously the Federalist Papers were written in support of the Constitution. The Anti-Federalist Papers were written opposed to adopting the Constitution. The Federalists written by Madison, Hamilton, and John Jay, who would later become the first U.S. Supreme Court justice. And as with the Massachusetts Compromise, what was adopted was the idea that the Bill of Rights be added to the Constitution. And ultimately, Massachusetts did go along with that. So did 4 other states following. And we got to 9 states of ratification. It went into effect. And then the Bill of Rights was passed by Congress. It was originally 12 amendments sent to the states. Only 10 of them were adopted. One of them later became the 27th Amendment. But those 10 became the Bill of Rights to go ahead and also specify that in addition to the federal government with limited enumerated powers, we would also have a Bill of Rights that would reserve certain powers to the people and that would ensure that certain individual liberties were not violated. So the first constitutional question was actually over the Bank of the United States. Madison and Hamilton, who had been the 2 chief drafters of the Federalist Papers, got involved in that, with Congressman Madison arguing that you could not create a bank, and Hamilton was Secretary of the Treasury at the time, said you could. So there you've got the Congress and you've got the executive discussing the issue. Hamilton ultimately won under the Necessary and Proper Clause. Move on to the state foreign sovereign immunity issue just a few years later in 1793. And the Supreme Court there ruled that you had in a dissent, you had Justice Iredell saying, well, the King of Britain had to consent to being sued. Interesting argument. However, he was in dissent, and the ultimate holding was, no, we're not going to follow the common law when the common law conflicts directly with the Constitution. This written Constitution is the law of the land, and it is what rules. And those who have problems with it will have to change it, and that's exactly what they did. They adopted the 11th Amendment on state foreign sovereign immunity. The Alien and Sedition Acts were the first major issue in which the whole idea of talking about these particular constitutionality by the states took place. And those Alien and Sedition Acts had said that the president can actually remove folks who are foreign citizens, and also went on to say that any sort of, with the Sedition Act, said that any sort of defamatory remarks made about the president or the Congress, that if those statements took place, then that would be punished as a crime. Obviously, this was put forward by the Federalist Party, not to be confused with the Federalists who had opposed the Anti-Federalists, but this was now the Federalist Party that was opposed by the Democratic Republican Party. And the Democratic Republicans, Madison and Jefferson in particular, went about writing certain ordinances. The Virginia Resolution, which we discussed last time, and the Kentucky Resolution, Virginia written by Madison, Kentucky written by Jefferson. And they declared those Alien and Sedition Acts to be unconstitutional. However, this issue then became moot shortly thereafter, after the election of 1800, because at that point the Democratic Republicans took over and had control, and those particular laws were either repealed or they simply went out of effect. With Maharrey versus Madison, as the sponsor of the bill mentioned last time, did not come until 1803, and there you've got a quite clever argument by the Chief Justice that Marshall that he was actually giving up power, ceding power. What he said was, the court cannot issue writs of mandamus, which was simply an order to an executive to do or not do a certain thing. So on its face, he was making an argument to give up power of the judiciary. Of course, the secondary argument underneath that is, well, in fact, it's the courts who get to decide what is and what is not constitutional. So it was really a brilliant argument in the sense that it could not be challenged because he was giving up his own power. So the executive and the legislature could not challenge his giving up his own power in that way, and that idea of judicial review was placed into U.S. Supreme Court tradition through that. Moving on, just a few years later, 1810, the court struck down a state law as being unconstitutional under this idea of judicial review. 1819, the court agreed with Hamilton, said that that U.S. could create a bank and that Maryland could not tax it. And then we get to the issue of Jackson, and that's what we discussed a good bit last time in Jackson. I mentioned Jackson in particular because he was a very interesting figure on this subject. He had some really disparate views from those that are carried by a number of people today and even at the time. He, first of all, was faced with the issue of constitutionality over the Worcester versus Georgia case, in which point that was a set-up case. And you had a missionary who was going down into Georgia and working on some tribal American Indian lands. He was arrested at that time, and the issue went up to the court as to whether or not the state of Georgia had authority over those tribal lands. And the court said they do not. And so they struck down this criminal statute on the Georgia books. Jackson, of course, is always quoted as having said, Chief Justice Marshall has made his decision, now let him enforce it. He did not, in fact, say that. What he did write was, the decision of the Supreme Court has fell stillborn, and they find that they cannot coerce Georgia to yield to its mandate. So he wasn't particularly excited about enforcing the Supreme Court decision against Georgia. However, later, a good bit later, Georgia did finally release those two missionaries, and that avoided a constitutional showdown at the time. But he had another issue that came up right at the same time, in which the second bank of the U.S. had now been passed through the Congress, which he very much opposed, and he vetoed it. In his veto message, he said, the Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it, not as it is understood by others. It is much the duty of the House of Representatives and the Senate and the President to decide upon the constitutionality of any bill or resolution which may be presented to them for passage or approval, as it is of the Supreme Judges when it may be brought before them for a judicial decision. The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point the President is independent of both. However, so he was very clear that he had a duty to uphold the Constitution and to uphold his oath of office as well. However, in this particular instance, much like Chief Justice Marshall in Maharrey versus Madison, he was limiting his own constitutional power in that instance, and he was saying that he did not he was not able to sign a bill that he felt personally was unconstitutional, and that was creating the Second Bank of the United States. So there really was no constitutional crisis there because he was not challenging the authority of the court directly. He was limiting his own power.
I have a question on that point.
And then we'll just continue, and then we'll take discussion right after that. And then we get into that nullification crisis of 1832, which is the one that's really on point for what we're talking about today. And we had this tariff of 1828. We had that was benefiting the northeastern manufacturing industry at the expense of the southern agricultural interests. Southerners were very much opposed to it. And even the vice president of Jackson, John Calhoun, went as far as to resign, to go down to South Carolina, be elected U.S. Senator to try to fight it. And ultimately, Jackson signed a compromise tariff in 1832 that lowered the tariff, but it still didn't eliminate it. It still existed on the books. And South Carolina still opposed the tariff, and that is when they adopted a nullification ordinance. Now, theirs was not nearly in as soft language as had been in the Virginia and Kentucky resolutions. They said the two acts are, quote, null, void, and no law, nor binding upon this state. They directed the state legislature to enact laws to enforce it. They even said judicial proceedings upholding these acts are going to be null and void. And they said that every official, even jurors, must take an oath to enforce this ordinance. They also said if Congress tries to close a port or send a military or naval force against the state, South Carolina will leave the Union and, quote, organize a separate government. So they were pushing this issue where it ultimately goes, which was where it ultimately went, and that was to the Civil War. Jackson's response was pretty clear. I consider then the power to annul a law of the United States assumed by one state, here's what he said, incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, inconsistent with every principle on which it was founded, and destructive of the great object for which it was formed. So when faced with this idea not of separation of powers among the three branches of government, but when faced with this idea of a state government now nullifying even a federal judicial decision, at that point Jackson was clear that he considered that to be incompatible with the existence of a union. He sent to Congress a force bill allowing him to send troops to South Carolina and giving him the authority to enforce the tariff. In the meantime, a compromise tariff was worked out in the Senate to reduce the rates even further. The force bill also passed. South Carolina avoided the controversy and ended the standoff by actually going ahead and nullifying the force bill, but rescinding the nullification on the tariff. And so that's where we were. We had a few years to buy. But then the Dred Scott decision came out, creating this idea of substantive due process, saying that the due process clause is not just procedural, but in fact there's substance about it, and throwing out the idea that there are some acts that are so inherently immoral that they are to be rejected, and there is no process through which you can go that can make them authoritative and make them legal. And what that ultimately did, of course, was it allowed a slave who had been taken into freed territories to still be counted as property. And at that point, this compromise over having some slave states and some free states was gone. And then we had the Civil War, 1861 to 1865, which solved many issues, as many wars do. Some people think wars don't solve issues, but most of the times wars do solve issues and answer questions. A court packing plan, I'm going to jump ahead here because we know most of the rest of this since then. We had that same idea of, well, the 13th, 14th, and 15th Amendments were adopted, of course, right after the Civil War, repealing slavery, abolishing it, telling what is citizenship of the United States, putting in the Equal Protection Clause, and then with the 15th Amendment, voting rights, ensuring voting rights for all Americans, all males at the time. And then this idea of, as we move forward, there are a few other ideas floating around there, and getting in the 1900s of economic substantive due process, where where the court is repealing or is striking down even state statutes on wage and hour laws, saying, nope, you can't do that. FDR didn't care too much for that when his New Deal program was being struck down. So, of course, he came up with this court packing plan in 1937 to try to move the court from 9 justices to 15. That was ultimately not adopted by the Senate. In part, it was to, in part also, the court had switched. Of course, we had the switch in time that saved 9. It says nowhere in the Constitution how many justices we have to have, but we've had 9 ever since 1868. And that switch by Justice Roberts allowed the court to continue on and actually to uphold that New Deal legislation, even that was affecting wage and hour laws. We get into the height of the Commerce Clause. We've talked about that in this bill's history before, with the Wickard versus Filburn case that came out in 1942. Even one person growing wheat on his own farm is engaging in interstate commerce because he is not purchasing wheat off of the market, was the argument. So you got the real height of that Commerce Clause there. The incorporation doctrine came into play throughout the 20th century. Arguably, you can trace it to the Gitlow versus New York case of 1925. But here the idea is that the court says, well, the original Bill of Rights, the first 10 amendments of the Constitution, they only applied as constraints on federal power. But then the court, throughout the 20th century, said, no, in fact, because of the Due Process Clause in the 14th Amendment, which we already had a Due Process Clause in the 5th Amendment that applied against the federal government, but because of the Due Process Clause in the 14th Amendment, at that point now we're going to use that, and under a type of substantive due process argument, say that all the first 10 amendments, or certainly at least the first 8, also apply as constraints on state power. Brown versus Board of Education came out in 1954, saying that separate but equal is not equal under the Equal Protection Clause. And then we have more civil rights legislation that was upheld, once again, on the Commerce Clause discussion in 1964, the Civil Rights Act of 1964. You had 2 cases that came out there, the Heart of Atlanta Motel, and at this point, of course, the Congress had not only talked about and had not only gotten into the public discrimination, but now you're talking about discrimination by private, in this case, private employers, private restaurants, private hotels, privately owned, that is, but open and serving the public. And the court said the Heart of Atlanta Motel actually was serving 75% of its patrons that were coming there from out of state. So the Heart of Atlanta Motel was, in fact, engaging in interstate commerce, and Congress could use the Commerce Clause to get to and regulate that activity and to say that racial discrimination, which was awful, that could be outlawed. However, the Katzenbach versus McClung case that came out the same day dealt with Ollie's Barbecue in Birmingham, Alabama, and in that case, the court had to make a more of a stretch of an argument there in finding that 36% of the meat of Ollie's was bought from one local supplier, and all of that supplier's meat came from outside of the state. So that's where it stood in 1964. We had substantive due process flipped since it had gone away against economic rights, and now it came back into play in 1965 in the Griswold versus Connecticut case as applied to individual liberties. There you had a test case with a criminal citation involved, in which there was a criminal fine for dispensing birth control in Connecticut. And the court found specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. And it found a Ninth Amendment implied right of privacy and struck down the state statute in that case, which ultimately led to the 1973 case, Roe versus Wade, that we are more familiar with. Finally, we get to the Rehnquist court, or at least when Justice Rehnquist was on the court in 1995, and there began to appear limits on the Commerce Clause. In the U.S. versus Lopez case in 1995, the Gun-Free School Zones Act of 1990, which had made it a federal crime to carry firearms within 1,000 feet of a school, that was found not to fall within the Commerce Clause powers of Congress. So for the first time in certainly since the beginning of the 20th century, you now had the Supreme Court pulling back on the authority that it was willing to grant to Congress under the Commerce Clause. U.S. versus Morrison in 2000 continued that line of reasoning and struck down portions of the Violence Against Women Act, which had made it a crime to commit certain crimes motivated by gender. Gonzalez case, Gonzalez versus Rake in 2005, to some extent went the other direction in saying that no, California cannot violate the congressional powers to regulate drugs. California was engaged in medical marijuana, as it still is, as a matter of fact. And they said that Commerce can regulate that because that's ultimately part of a larger economic system of regulating drugs. And then, of course, finally, the most recent case on the Commerce Clause power of Congress is the NFIB versus Sebelius, otherwise known as the Obamacare case, from just this past summer, in which case the court on that one specific Commerce Clause issue said that Congress does not have the power to create commerce and then regulate it. And they struck down, on Commerce Clause grounds at least, the individual mandate, the requirement that individuals be forced to purchase health insurance, and then that purchase then be regulated. Now that, of course, it was obviously upheld on the Taxing and Spending Clause. And then we have a couple of other, to round it out, a couple of other Second Amendment cases from 2008 and 2010. One was mentioned in here yesterday. The D.C. versus Heller case struck down the D.C. handgun prohibition, which even prohibited firearms in the homes in D.C. And then that particular Second Amendment provision was also incorporated to apply as a limitation on state power in the 2010 case of McDonald versus Heller that was out of Chicago. So right here in the middle of these 2008 and 2010 cases, we had Senator Beaver's original bill, which I supported. And it said that as Tennesseans, we think that our firearms or ammunition that is produced within the state boundaries and that does not leave the state boundaries is not subject to regulation under the Interstate Commerce Clause. And I supported that. And this particular bill does a number of other things in addition to that. And with that, Senator Beavers, you're recognized to describe the bill again.
Thank you, Mr. Chairman. We have two witnesses today. We have Mr. Maharrey from the 10th Amendment Center. If he would come to the front, he has some testimony.
Without objection, we'll go into recess to hear from Mr. Maharrey. Which, if you would, please have a seat at one of the chairs here. Make sure your green light is on and state your name and title for the record, please. And we've got a total of 5 minutes to be. Is this to be divided, Senator Beavers, among anyone? Or is it just Mr.
Yes,
Maharrey?
we have one more witness.
Okay, to be divided between yourself and one other witness. Thank you.
So I only make sure I'm on. So I only have I have 2.5 minutes. Is that what we're saying?
However you like to divide up the 5 minutes. Yes, those are our committee rules. Thank you.
Mr. Chairman, I think you told me yesterday they would have 5 minutes each.
I'm sorry, Senator Beavers. Our committee rules are 5 total minutes among all presenters on a side. Those are our rules that we announced at the beginning of the committee this year in January. But we can't. They can take questions afterward. I assure you, there will be questions. I assure you, Senator Bell. You. Yes.
Mr. Chairman, those are the clearly stated committee rules that you stated at the beginning of the year. There does seem to be, and I didn't know this until she just said it, a misunderstanding that she thought that you told her yesterday that the witnesses could have 5 minutes apiece. I'm going to make a motion that we suspend the rules in this case because of a misunderstanding. I would not have made that motion if there had not been a misunderstanding between yourself and the sponsor, at least on her part. At least on her part. I'm going to make a motion that we suspend the rules on this for this one time of testimony, that each of the presenters have 5 minutes apiece.
And there's a motion. There is a motion and a second on that. Is there any objection to that? Seeing none.
Can I have a quick
Senator Green, you're recognized.
The motion that's made. Thank you, Mr. Chairman. As I understand it, this is the bill we're discussing for the rest of this special called session. Is that correct?
I imagine so, yes. I think we have 30.
We have 30 minutes.
We have 31 minutes, yes.
Okay, just wanted to.
Okay, without objection, that is so ordered, and you're allowed 5 minutes, Mr. Maharrey.
Okay, I appreciate that. Thank you very much. My name is Michael Maharrey. I'm the National Communications Director for the 10th Amendment Center, and I'm very honored to be here with you guys today. I'm going to address the Attorney General's opinion on this particular bill. As you probably know, in the opinion of Attorney General Robert Cooper, SB 250 violates the Supremacy Clause of the Constitution. And I've read his opinion, and his basic reasoning is very solid. Nevertheless, he came up with the wrong answer. Now, I'm sure you guys all remember working those long quadratic equations back when you were in high school algebra class, and you know that you can work all of the steps absolutely correctly, but if you do an addition or subtraction error in your very first step, you're going to come out with the wrong answer. Why? Because you've worked the problem working from the wrong premise. Cooper spends the bulk of his opinion correctly arguing that constitutional federal law trumps state law where it conflicts. Quite frankly, that was a waste of time. Nobody disputes that. The problem is that he incorrectly assumes that every federal act is constitutional law, and he builds his opinion on this fallacious premise. Fact: only laws made in pursuance of the Constitution are truly supreme. All of the Founding Fathers agreed, and I mean all of them, that any federal act that violates the Constitution is no law at all. Hamilton summed it up in Federalist 78. He said, every act of delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid. Cooper apparently wants the people of Tennessee to believe that the following federal acts mentioned in Section 5B of SB 250 are constitutional and therefore supreme: a ban on firearms, tracking of ammunition, federal taxes on firearms accessories, among other things. Where exactly does the Constitution delegate the federal government power to regulate firearms? It doesn't. Now, some will argue that there's some regulatory authority under the Commerce Clause. But we have the Second Amendment. And the Second Amendment puts further restrictions on the federal government. And we have to keep note of the most important phrase in the Second Amendment: shall not be infringed. Infringed means to interfere with. That leaves no wiggle room. Now, Cooper mentions the possible unconstitutionality of these acts almost as an afterthought. He writes near the end of his opinion, while the bills themselves declare that certain federal firearms regulations are unconstitutional, the responsibility for that determination rests with the judiciary, not a state legislature. Now, the Attorney General rests his argument on the Marbury versus Madison case, and I know we've talked about that in this committee earlier. But Cooper is misconstruing the Marshall ruling. Chief Justice Marshall was merely asserting that the court can, in fact, nullify an act of Congress by ruling it unconstitutional. Nowhere does Marshall assert that the court has exclusive authority to rule on constitutionality. In fact, quite the opposite. He wrote this: the particular phraseology of the Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument. Now, the Attorney General also cites Cooper v. Aaron to assert the supremacy of the federal judiciary and that its rulings cannot be challenged. That case also rests on this same bastardized interpretation of Marbury. Such a notion obliterates the constitutional system, making the court the de facto sovereign. I shouldn't have to point out the absurdity of the court making itself supreme. It's like King Arthur claiming supreme executive authority because, in the words of Dennis and Monty Python and the Holy Grail, some watery tart threw a sword at him. Ronald Reagan, Attorney General Edwin Meese, said this about the Cooper decision. He said, the logic of Cooper versus Aaron is at war with the Constitution, at war with the very meaning of the rule of law. We need look no farther than the Dred Scott case, which was brought up just a few minutes ago, which denied even free black citizenship and went on to proclaim black people as inferior, to see the inherent flaw in this idea of judicial supremacy. Do you really accept that the Dred Scott was legitimately the law of the land even for 1 minute? Abraham Lincoln certainly did not. In response to the ruling, he said this: if the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Fact: the Attorney General tells us that only the federal court can determine constitutionality. Fact: Ronald Reagan Attorney General Edwin Meese, Abraham Lincoln, James Madison, Thomas Jefferson all disagreed. Jefferson said this, and I think what we need to do here while we're considering this bill is to try to unravel his logic. He said the states are not united in the principle of unlimited submission to their federal government, and the government created by this compact, the Constitution, was not made the exclusive or final judge of the extent of powers delegated to itself. Simply put, the people of the states delegated the federal government its power in the first place. As Madison said, the states then, being parties to the constitutional compact, in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact, the Constitution, made by them is violated, and consequently, that as parties to it, they must themselves decide in the last resort such questions as may be the sufficient magnitude to require their interposition. Thank you very much.
Thank you. And why don't you just go ahead and stay here, if you don't mind, maybe scoot down a chair. Or actually, you're fine there. And then we'll take our second speaker can come sit beside you as well.
Should I turn this off?
Yes. Just press it one more time. And again, thank you very much for being with us today for this very important issue on constitutional issues. And we appreciate your words. We've got 5 minutes. If you would, please make sure your green light is on and then state your name and title for the record. Thank you.
It is on. My name is Publius Huldah. I'm a retired litigation attorney, and I write on the original intent of the Constitution using the Federalist Papers. I do not go by Supreme Court opinions because for 200 years, the Supreme Court has been ignoring the Federalist Papers and the Constitution our framers given, and they have gone off on tangents of their own which have nothing to do with the Constitution. The Attorney General's opinion begs the question. He states that states can't nullify acts of the federal government which are authorized by the Constitution, but then he completely fails to cite article, section, and verse, a clause, where the Constitution delegates to Congress authority to restrict our arms. When we ratified the Constitution, we created the federal government. We listed, enumerated every power we granted to our creature, the federal government. Article 1, Section 8, Clauses 1 through 16 lists most of the powers we delegated to Congress for the government, for the country at large. We didn't put on our list that our creature could restrict our arms. We didn't delegate this power to Congress because our framers wanted the American people to be heavily armed. Alexander Hamilton and James Madison write about this in the Federalist Papers. In Federalist Paper number 46, James Madison writes, why the American people are armed. It is so we can defend ourselves, our communities, and our states from the federal government in the event it becomes tyrannical and oversteps the constitutional limits on its powers. In Article 1, Section 8, Clause 16, pursuant to that, Congress passed the Militia Act of 1792, where they required every able-bodied male citizen between the ages of 18 and 46, except for federal officers and employees, to buy a rifle, ammunition, and report to their local militia for training. Pursuant to Article 1, Section 8, Clause 11, Congress is authorized to issue letters of marque and reprisal. This is what authorizes private warships to make war on our enemies. These were the privateers who fired on British ships during the War of 1812. Our framers contemplated a people who were heavily armed. That is why we never delegated to our creature authority to restrict our arms in any fashion whatsoever. And when the federal government attempts to do so, they are usurping powers which they do not possess. The Attorney General goes by court opinions, not the Constitution. There is a vast gulf between the two. We have 200 years of Supreme Court opinions, and Mr. Chairman very kindly shared some of these 200 years of Supreme Court opinions, which have nothing to do with the Constitution. Charles Evans Hughes said over 100 years ago, the Constitution means what the judges say it means. That has been the prevailing dogma ever since, and generations of lawyers have been indoctrinated with this lie. That is why we no longer have a federal government which is held down by the chains of the Constitution. What we have is rule by five judges on the Supreme Court who claim the power to do whatever they want to us and our country. So today we have two opposites, what the Constitution says and what the Supreme Court says. Well, your oath of office requires you to obey the Constitution, not the Supreme Court. The Supreme Court is merely a creature of this Constitution and is completely subject to its terms. My third point, the AG asserts that the that the Supreme Court is the exclusive and final authority on the extent of the powers of the federal government. But our framers knew that Supreme Court judges were as likely as anybody else to be corrupt, usurp powers, and act lawlessly. So Congress, the President, and the states all have checks on the Supreme Court. Hamilton shows in Federalist Number 81 that Congress's check on lawless federal judges is to impeach them and remove them from office. The President has his oath of office as a check on the Supreme Court. The President's oath is to preserve, protect, and defend the Constitution. It is not to obey the Supreme Court. The Supreme Court was not set up in our Constitution as the superior branch of the federal government. And then there's no need for me to Madison says in his report on the Virginia resolutions that it is a plain principle founded in common sense that the states, as the sovereign parties to the Constitution, are the final authority on whether the federal government has violated the Constitution, and that the states may check all three branches of the federal government, not just, they may check the judiciary, the executive, and the legislative branches by nullifying their acts. If the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed if we do not stop them. This is what James Madison said in his notes on nullification, in his report on the Virginia resolution. I'm sorry I didn't have time to finish. I hope that during questions someone will ask me about the so-called nullification crisis of 1832.
Thank you very much for your comments, and we appreciate your staying here for questions. Ms. Huldah, I think you have correctly pointed out that ultimately this bill is not about Second Amendment rights. If it were about the Second Amendment rights, we'd have the NRA down here asking us to support this bill.
It's about enumerated powers.
This bill is about constitutionality and who decides constitutionality.
Well, first it's about...
In your opinion, excuse me, ma'am.
Yeah.
Sorry, thank you.
Sorry.
In your opinion, who decides constitutionality?
Okay, first, I do not have any opinions. All I do is channel our framers, the Federalist Papers, and other original source writings. Our framers all said, James Madison, Thomas Jefferson, Alexander Hamilton, among others, said that in the last resort, the states are the final authority. The federal government is merely the creature of the states. The states, as sovereign members of the Federation, retain the ultimate authority to decide.
Okay, so the states have the ultimate authority to decide issues of constitutionality over the federal judiciary, federal Congress, and federal...
Right. That is what James Madison, Alexander Hamilton, and Thomas Jefferson said.
How do you square that with Federalist 78, in which Hamilton said, by a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be, to declare all acts contrary to the manifest tenor of the Constitution void. All the reservations of particular rights or privileges would amount. Without this, all those reservations of particular rights or privileges would amount to nothing.
I was hoping you'd ask me a hard question, Mr. Chairman. It is in the first resort the Supreme Court may pronounce on the constitutionality or unconstitutionality of acts, but in the final resort, The states have this power. And if you look at the next paragraph just after the one you just read, you will see where Hamilton says that the states, that the people are the ultimate authority.
Do you
just in the paragraph just after the one you read.
Did you agree with the opinion of the Anti-Federalists?
Again, I don't have any opinions. All I do is say what our framers said. This is not ever properly a matter of personal opinion. But what did our framers say?
So I don't know what they said about this.
Well, I'm telling you what they said about
Anti-Federalists.
I've told you what our framers said about nullification, and in my latest paper.
Excuse me. How about, let me ask it in a different way. The Anti-Federalists, Robert Yates, said the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort, to determine what is the extent of the powers of the Congress. They are to give the Constitution an explanation, and there's no power above them, to set aside their judgment. That was, of course, written in protest to the Constitution and against its passage, but nonetheless, it was actually giving the sentiments that had been laid forth by the Federalists in the Federalist Papers that you
Right.
read.
The Federalist Papers were written in part in response to the Anti-Federalists to answer their objections, and many of the Federalist Papers address what they say are spurious objections. So that is a spurious objection. Of course, our Constitution doesn't delegate supreme power. It doesn't invest the Supreme Court with godlike status.
And do you believe that Madison, in your testimony, did Madison believe in the idea that states could nullify federal laws?
Madison has written 2 definitive works on this. His report to the Virginia legislature in 1799 and 1800. And then his notes on nullification written in 1834. I have hyperlinks to these original source works in the last paper on my website. I urge everybody to read these original source works by Madison for themselves. Madison is the one who said that ultimately the states have the right to determine the constitutionality of acts of all 3 branches of the federal government.
He also said in that same report to the Virginia State House of Delegates, the declarations in such cases are expressions of opinion, speaking of course, the Virginia resolution that he had drafted himself, which had said that the Alien and Sedition Acts were unconstitutional. He's speaking about his own writings. He said, those are expressions of opinion, unaccompanied with any other effect than what they may produce on opinion by exciting reflection. Expositions of the judiciary, on the other hand, are carried into immediate effect by force. The former, speaking about the Virginia resolution of the state, may lead to a change in the legislative expression of the general will. So that hopefully they could change the opinions of Congress and the expressions of the opinions through congressional law. However, he said possibly even to a change in the opinion of the judiciary. The latter, speaking of the judicial decisions themselves, the latter enforces the general will. That's exactly what he said in that report.
Okay. You are reading from Madison's report on the Virginia resolutions written in 1799-1800. Are you reading his discussion of the 7th and 8th resolutions? Are you? Is that a yes? Okay. In the 7th and 8th resolutions, all Madison was talking about was that the states have the right to get together and discuss this and object. That was not the meat of it. The meat of what he said is in Madison's discussion under the 3rd resolution, and that is the one which I quote at length in my paper, James Madison Rebukes Nullification Deniers. So you're reading from a point which isn't relevant. The main discussion is under resolution number 3.
when he begins talking about that, it does begin to read as if he's talking about he's favoring the ideas of states having power until you get to his conclusion, in which case he says, no, these are actually just expressions of opinion, and it's the
Right,
court's decision which are enforced through effect.
No, he's
We
talking
can
about how the
disagree on
states
that one.
can get. It isn't a matter of personal opinion, it's fact.
What question did the Civil War answer?
The question it answered was whoever has the most power wins.
And who had the most power?
Well, I am not an expert on military strategy.
Who won?
Bad guys.
Who won?
That doesn't answer anything about whether or not states can nullify lawless usurpations of power by the federal government.
So the Civil War did not answer any questions.
May I address this? Are you suggesting that
Sorry.
if I'm sorry.
I'm sorry. I've got one last question for Ms. Huldah, and then we'll get to you. Yes.
Well, I hope someone will ask me about nullification crisis.
Yes. And so the Civil War did not answer any questions.
Are you suggesting that because the North won, that the rest of us, that all of the country for the rest of our lives must submit to everything the federal government does?
Can you point to one shred of evidence post-1865 that supports the idea that nullification is legal?
This is the Constitution that was ratified. It is not something which changes with the whims of judges. That is the complaint I have, that for 200 years we have this body of constitutional precedent which has been built up, which has nothing to do with the Constitution.
Okay. Thank you, Ms. Huldah. Senator Overby and then Senator Cantfield.
Well, thank you, Mr. Chairman. I really didn't catch the witness's name.
Publius Huldah. When the Federalist Papers were first published in newspapers, even though they were written by Hamilton, Madison, and Jay, they were published under the name Publius. And Huldah, of course, is the Old Testament prophet at 2 Kings 22. The book of the law had been lost, but then it was found when the renovations were being made to the temple. And King Josiah said, well, take it to Huldah and see what she says. And she said, this is the law.
So is that that's an assumed name?
That is my nom de guerre, my pen name.
What is your name?
You know, you make me out to be a fascinating person. I'm just a little old lady who was puttering around in her garden studying biblical Greek until 4 years ago when I saw what trouble we were in, so I got my copy of the Federalist Papers, dusted it off, and started writing about the original intent of the Constitution. Nothing is about me. It's about our Constitution. It's about our country. So let us stick to what's important, not about personalities, because they are not important personalities. Our country is.
I would agree with you.
Thank you, sir.
But this is not about, you're right, this is not about personality. But, Mr. Chairman, every witness that we have who has testified since I've been in this General Assembly has identified themselves and who they are and where they, from whence they speak. And that was simply my question, to get it on the record as every other witness has done. Thank you for the opportunity to ask, Mr. Chairman.
We'll hear from the sponsor and then Senator Cantfield.
I just wanted to say that the chairman and I had an understanding about all of that. So,
Senator Cantfield.
Thank you. Either of the witnesses, can you tell me, did the Civil War itself end slavery? Or did the Constitutional Amendment end slavery?
Technically, it would be the Constitutional Amendment, the 13th Amendment, because the Constitution provided for it until the 13th Amendment. That was what fixed the defect.
So it wasn't the war itself did not fix it. It was actually the changes to the Constitution brought by the people, brought by the states, that actually changed it. Is that correct?
That is correct, sir.
Thank you. I have some other questions, but I have a question. Can you tell me a little bit more about the case of 1832 that you were referencing earlier?
Yes. Thank you, sir. My favorite question. In the 1820s, South Carolina was an agricultural state. She produced cotton. She bought her manufactured goods from England. England bought Southern cotton. Now, there were infant industries in the Northeast who were manufacturing some of the same goods that England produced, but the domestic goods were more expensive than the English imports, so they couldn't compete. So in 1828, Congress passed the Tariff Act of 1828, which imposed a high tariff on the English imports. This made the goods too expensive for the southern states to buy, so they stopped buying them. English retaliated by stopped buying southern cotton, and this greatly weakened the southern economy. South Carolina attempted to nullify this. She developed a peculiar doctrine of nullification, which said that any state could nullify any federal law, and the nullification would be presumed to be valid unless 3/4 of the states in the convention said that the nullification was not valid. Now, James Madison opposed South Carolina's doctrine of nullification, and this is why. Article 1, Section 8, Clause 1 specifically delegates to Congress authority to impose tariffs, and further, it requires that the tariff be uniform in all the states. So we couldn't have a situation where South Carolina was paying no tariff, but the other states were paying the tariff. So South Carolina tried to nullify a constitutional law. That was the determining factor in this, that the Tariff Act of 1828 was fully constitutional. So in 1834, James Madison wrote lengthy notes on nullification, and he pointed out, 1, the Tariff Act is constitutional. States cannot nullify a constitutional law. 1/4 of the states don't have the right to dictate to 3/4 of the state on matters which are in the delegated powers of the federal government. And finally,
I'm so sorry to interrupt you, but we only go until 1 o'clock. So if you could just keep your answers as short as possible, that would very much help us out. We have Senator Stevens.
I still have questions. I have 2 more questions before I'm done with her.
Okay, very quickly.
Okay.
We got Senator Stevens, Senator Green, and then we'll be done.
Okay, very briefly, what do you think was the purpose of the 10th Amendment? And we talked about what the Constitution has been, how the Constitution has been changed. Has there been any constitutional amendments that removed the 10th Amendment that I missed somewhere?
no.
Okay.
No.
What is the purpose
Senator
for the
Canfield,
10th
last
Amendment?
question.
Just to make it clear that the Constitution we ratified, the Constitution everybody voted for, is one of limited enumerated delegated powers. Depending on how you count, only 21 powers were delegated to Congress. None of them is the right to restrict our arms. The purpose of the amendments was just to reassure some of the states who were nervous about the federal government having too much power. And the 10th Amendment says, you know, we really mean it, where we enumerate the powers in here. We really mean that that's all they have, and that the federal government has everything else. James Madison discusses this the best in Federalist number 45 at the fifth or the 9th paragraph.
Okay. Thank you very much.
Senator Stevens.
Yes, Mr. Chairman, thank you. The examples of overturned nullification mentioned by both yourself and the AG, at least as I've looked at them, all seem to be examples of states attempting to nullify federal law that was in fact constitutional. Are there any examples of overturned nullification efforts where the federal law was unconstitutional? And that's a question to either the witnesses or yourself, Mr. Chairman.
My problem is that we're getting into circular reasoning here. The witness stated that South Carolina nullified the act, but that the act was constitutional. Well, that's the whole question, is who gets to decide whether it's constitutional. And if the testimony is that the states get to decide it, then the state decided. So I think that ends the question, but I'll let the witness answer your question.
Well, sir, that's very easy. Article 1 of Section 8, Clause 1 delegates to Congress authority to impose a tariff.
Obviously, it wasn't very easy for South Carolina. And the
no, South Carolina said you can nullify constitutional laws.
Excuse me, I'm sorry. And that they said that they have the final authority on that. But let me go back to Senator Green.
Yeah, Mr. Chairman, if I could, though, nowhere in our history has there been an attempt to nullify a federal law that was unconstitutional. So we don't really have a record, right? And nowhere in the Constitution does it state otherwise that states can't. Other than you would cite the Supremacy Clause.
I am not trying to dodge the question, but the question really is circular, because you're assuming that you personally have the ability to determine constitutionality. And what I'm asserting is that the Supreme Court, according to Madison, had the ultimate... No, not in Marbury versus Madison. Okay. According to Madison himself in the Federalist paper, Hamilton in the Federalist Papers, Madison himself in his report to the Virginia House of Delegates, and then also Marshall in the Marbury versus Madison, they said the court did, and that's ultimately the question, is who has the ability to do it.
That is not correct, sir.
I know we disagree on that, but Senator Green.
Yeah, if I could also state, I do want to bring up one Supreme Court case very quickly, if I could. It's a case called Reed versus Covert. In this case, Miss Covert was the wife of a military soldier assigned to England, and while she was in England, she killed her husband. The United States had a treaty which, according to the Supremacy Clause, essentially makes it equal to the law of the land, and that treaty should, per the Supremacy Clause, have had priority. However, the court's opinion stated that the Fifth Amendment and the Sixth Amendment essentially overrode the Supremacy Clause. They limited the Supremacy Clause because they were limits as a part of the Bill of Rights on the federal government. So it would seem intuitive then that so would the Second Amendment.
And with all due respect, that is a misunderstanding of the Supremacy Clause. The Supremacy Clause says that the Constitution is the supreme law of the land, and that acts of Congress, and including treaties that are ratified by the Senate, that are entered into in pursuance of the Constitution, are also valid federal law. However, they cannot be trumped by the Constitution, and that was the issue in this particular case. The court ruled that the Constitution itself, and in this instance the Fifth Amendment, is what had prohibited that particular treaty from being enacted in pursuance of the Constitution itself, and that was the issue in that case.
Right, and I guess I misspoke. The point I was trying to make is that from a pure reading of the Supremacy Clause, and it does say in pursuance, I understand that. But the Bill of Rights and those amendments do, as they are part of the Constitution, make any effort to usurp them inappropriate and unconstitutional. So any effort with the Second Amendment, whether it be a state law or a federal law, that is unconstitutional according to those amendments, I think we have a right to stand opposed to that.
Senator Stevens.
Thank you, Mr. Chairman, and thank you for your testimony today.
Yes, sir.
When you made the statement that the adoption and the ultimate power lies in the states, or something to that effect,
yes,
correct? Sir. When you say that in reference to the founders as well, didn't they put that in the Constitution in Article 5 of Section 3?
Ms. Huldah.
Don't the states act upon the Constitution by ratifying amendments to the Constitution?
That's one way, but that does not preclude, according to James Madison, Thomas Jefferson, and Alexander Hamilton,
But
nullification.
But
Senator Stevens.
the Federalist Papers weren't adopted by the states, correct?
No, sir, but they were considered as the most authoritative commentary on the original intent of the Constitution until Charles Evans Hughes said, the Constitution means what we say it means.
Well, but the Constitution was adopted by us,
Right,
people,
right.
through the amendment process, correct?
Well, through ratification.
Right, but not the Federalist Papers.
No, but the Federalist Papers were considered authoritative on the genuine meaning. It's like advertising. These Federalist Papers were used to explain the proposed Constitution to the people and induce them to ratify it. So it's like advertising. This is what we were promised.
So you're asserting that outside of Article 5 or Section, outside of Article 3, Section 5, the states can act to amend or to change the Constitution outside of Article 3, Section 5?
No, sir. What I'm saying is that when the federal government makes a clearly usurpacious law, such as restricting our firearms, it is the duty of the states, imposed really by their oaths of office, to support the Constitution and to defend the Constitution from the attacks on it by the federal government. And that is what our framers said.
But didn't we enact that the judicial branch would rule something constitutional or not? And then if we disagree, we the people disagree with that ruling, we can change the Constitution through the amendment process. Isn't that what we adopted?
No, sir, that is most manifestly not what we adopted. What we adopted was a Constitution where the Supreme Court is every bit as subject to the terms of the Constitution as the other two branches. We, the people, are the creators. The federal government, including the Supreme Court, are merely our creature, and the Supreme Court is completely subject to the terms. And our framers understood that Supreme Court judges might usurp powers. That's why Congress has the power to impeach and remove them for usurpations.
We're down to about
Thank
about
you.
two
Thank you for your
minutes.
testimony. Thank you, Mr. Chairman.
Thank you. Senator Gardenhauer, last word.
I would love to hear the sponsor of this bill say some words.
If you would, please keep your seats here. Thank you. Yes. Senator Beavers, would you like?
Senator Bell, I don't know if you want to recognize him first.
Senator Bell.
Mr. Chairman, I do have something I want to say, but prior to the time we take a vote, do we plan on taking a vote today?
Yes, right now.
Okay, I want to, when we go back into session, my question or my statement is not to them, but when we go back into session, I'd like to be recognized.
We are back into session. Senator Bell, you're recognized.
Thank you, Mr.
Thank you
Chairman.
for your testimony. I really, really do wish we had more time to explore these issues. I really do.
No, we do.
They're very interesting. Thank you for your testimony.
Mr. Chairman, I have truly been fascinated by the discussion going on for the last hour, I guess, 45 minutes to an hour. I feel like a lot of the discussion has been up in the clouds, and I don't mean that in a demeaning or derogative way. Just it's been a very intellectual, scholarly discussion on your part and the research that you've done, and on the part of the witnesses. I've got a couple things that I'd like to say before we vote, and I would like to make a statement directed at and I'm in favor of this bill. I'm going to vote for this bill, but I do want to call out some of the people who have been, I think, saying some very unkind things about the chairman and other people who have legitimate problems with this bill. political discourse has to be civil. It has to be. And I've received some of the emails, and I've been copied on some of the emails that I know the chairman has received. And political discourse has to be civil, even when we disagree. And Mr. Chairman, again, I wanted to point that out, and I thank you for your leadership on this committee. The chairman earlier referenced the opinion of Chief Justice Roberts in the case concerning the Affordable Care Act. And I found at least a couple of quotes from that opinion relevant to this discussion. Chief Justice Roberts quotes Chief Justice Marshall nearly 2 centuries ago when he says that the question respecting the extent of powers actually granted to the federal government is perpetually arising and will probably continue to arise as long as our system shall exist. We're here today with one of those questions. We have a question that arises: where does the power actually lay concerning the regulation of firearms? And there are different opinions on this committee. I agree with the sponsor and the intent of her bill that it should be with the states. I would also like to point out that the Supreme Court, as has been pointed out, has made numerous decisions over the years, and later Supreme Courts have overturned those decisions. I looked up just a few. Lochner versus New York was overturned by Adkins versus Children's Hospital. Adler versus Board of Education was overturned by Keysishan versus Board of Regents, University of New York. Pace versus Alabama was overturned by Loving versus Virginia. Austin versus Michigan State Chamber of Commerce was overturned by Citizens United versus the Federal Election Commission. Wolf versus Colorado was overturned by Mapp versus Ohio. Plessy versus Ferguson was overturned by Brown versus the Board of Education. I bring those out just to again reiterate the point that the Supreme Court is not perfect. The Supreme Court constantly, over the last 2 years, has overturned itself and corrected earlier decisions. Mr. Speaker, thank you.
Thank you. Thank you for your words. Senator Campfield, if everyone could remain brief. Thank you.
Thank you. I will. Seeing as there is testimony and questions still being out there, and as I believe Senator Beavers would like to bring amendments, I move we adjourn until next time.
That's a proper motion. Is there a second? There is a second. We'll do this on a voice vote. All those in favor signify by saying aye.
Aye.
All opposed, no. No. In the ayes of the chair, the motion fails.
I would ask for a roll call vote on.
Roll call vote on the motion to adjourn.
Senator Bell? Votes aye. Senator Campfield? Votes aye. Senator Finney? Votes no. Senator Ford? Senator Gardenhire? Votes aye. Senator Green? Votes aye. Senator Overby? Votes no. Senator Stevens? Votes no. Chairman Kelsey?
No. 4-4, the motion fails. Senator Green, you're recognized.
Yes, very quickly, I also wanted to echo what Senator Bell had said, that everyone in this discussion seems to have a very genuine heart to do the right thing, and everyone seems to be approaching it from an honest and sincere heart and desire to do the right thing. So I commend everyone in the discussion, everyone. And the stuff that has been in the emails in a derisive manner is just inappropriate. I do also want to state that several years ago in 1982 on the plane at West Point, I took the oath to defend the Constitution of the United States against all enemies, both foreign and domestic. I went to war to defend this nation and this Constitution, prepared to give my life for its defense. There are thousands of Americans through history who have given their life defending the Constitution. I believe that Senate Bill 250 defends the Constitution of the United States, and therefore I will be voting for it.
Thanks, Senator Green. Senator Finney.
Thank you, Mr. Chairman. There's a member of the administration here. I think the governor is going to be tasked with defending this law. If it should become law, he will be tasked with carving a budget that prosecutes people who violate this law. And for that reason, Mr. Chairman, I ask very briefly if Mr. Arnold can come forward and tell us if the administration has a position on this bill.
I appreciate the request, but at this time that we've moved out of recess and we've got to move forward on a vote on this out of due respect to our fellow colleagues here.
Well, Mr. Chairman, I would point out that the committee has been addressed by someone who refuses to give their name, who has no opinions by her own admission, and I'm asking for a few seconds for Mr. Arnold, who represents the governor, to come forward and tell us what their position on the bill is. I don't think that my request is unreasonable given what we've listened to over the last hour. The rest of us have indulged this committee. If you've been glad to hear all this, I think it's certainly reasonable to hear what the administration's position is.
Then if you would, please put that in the form of a motion.
I would make that motion that we
Is there a
take
second?
30 seconds.
There's a second. All in favor signify by saying aye. Aye. All opposed, no.
Mr. Chairman,
Yes, madam.
I have an amendment that could affect their opinion. Could I have a chance to put the amendment on?
I asked if she speak a while ago. Okay.
We're going to have to go here in about 30 seconds. Could you give a yes, no, or neutral statement for the record, please? The motion did carry. Mr. Arnold. Yes,
okay.
sir.
Sammy Arnold, Governor's Office. Thank you, Mr. Chairman. Senator Finney, the position of the administration is flagged for money because of the cost. We're not working against the bill, but the administration does have significant concerns about the constitutionality of it as it's written right now. And if the bill were to get to the governor's desk, I think there's a good chance that he's not going to sign it if those concerns remain. So.
Thank you very much for that. With that, we are back into session, and thank you. The question has been put. There's a second. All those in favor of the previous question signify by saying aye. Aye.
What? No.
Okay.
Mr. Chairman, I have
the motion was for
an
the
amendment that we filed
previous
with
question,
the
and that motion in the eyes of the chair failed. And so we are back on the bill, and Senator Beavers has an amendment. Is there a motion on her amendment? It's moved by Senator Campfield and by Senator Green. We will take this amendment is the one that reduces it from a felony to a misdemeanor. Is that correct?
That's right.
Okay. All those in favor of the amendment signify by saying aye.
Aye.
All opposed, no. No. We'll take a roll call vote on the amendment. Mr. Moore.
Senator Bell.
Point of order.
Point of order. On point of order. Senator Bell.
I need the drafting code on the amendment.
The drafting code is 3865. It changes it to a Class A misdemeanor from a Class B felony.
And takes the fiscal note off of it.
And takes the fiscal note off the bill. Mr. Maher, would you please call the roll?
Senator Bell. Votes aye. Senator Campfield. Votes aye. Senator Finney. Votes no. Senator Ford. Senator Gardenhire. Votes aye. Senator Green. Votes aye. Senator Overby. Abstains. Senator Stevens. Votes aye. Chairman Kelsey. Mr. Chairman, we have 5 ayes, 2 noes.
5 ayes, 2 noes. The motion carries. The amendment is on the bill. And I would also like to point out for the members that we do have a written letter signed by the Tennessee Bureau of Investigation, Tennessee Sheriff's Association, Tennessee Chiefs of Police, in which they say that these federal employees are our neighbors. They go to school with us. They attend our churches. In essence, they don't want to arrest them. And that's what this ultimately is about. This is a bill that says that our individual sheriff's deputies will be going out and using deadly force of the law of Tennessee to potentially shoot and kill federal authorities for enforcing U.S. Supreme Court decisions. And if
Mr.
states have the
Chairman,
ability to nullify that under the Chicago ruling, then they have the ability to nullify the Chicago McDonald case, and that would allow for a prohibition of handguns throughout the city of Chicago, because the state of Illinois could simply nullify that decision from 2010, that McDonald decision. And so that's not what this is ultimately about. It's not about Second Amendment rights, or the NRA would be down here. This is about who has the final say on constitutionality. Senator Beavers, to close.
Mr. Chairman, I would just like to say it's now reduced to a misdemeanor, which means they could simply issue a citation instead of arrest.
Okay, Mr. Maher, please take the roll on the bill as amended. And the motion is to
I have not heard
to calendar.
Motion to call the question.
The motion is to calendar. Mr. Maher.
Senator Bell.
Point of order.
I'd like an opportunity to speak on the bill.
Senator Stevens, Senator Stevens, we have got to take a vote on this bill.
Point of order.
Point of order, Senator Canfield.
I did not hear a motion to call for the question. I did not hear a vote on the call for the question, and therefore I don't know if that's a proper motion to call for the question.
We are now 20 minutes
That does not change
into
the rules.
Senator Tracy's
That does not
committee
change
meeting
the rules
at
for a
this
committee
point.
meeting. If you wanted to roll
Senator
it,
Stevens has the last. Is anyone other than Senator Stevens want to speak? Senator Campfield and Senator Stevens. Senator Campfield, you've got the floor. Then Senator Stevens. Then we're taking a vote.
thank you. If you wanted to push, we could have rolled this on and continued our conversation. My question with point of order, I did not hear a call for the question, which would require a second and would be a motion that would be questioned before the whole committee. If you were going to make that motion, that's fine. But I think that's something that's taken of a vote. You do not automatically call for the question unless there's objection. You usually have to say something along the lines of call for the question. I did not hear that. If I missed it somewhere, I do wish to object. Thank you.
Okay. Now we're back for Senator Stevens to close without objection. So ordered. Senator Stevens. Senator Stevens.
I've spoken to my local sheriffs in 5 of the 6 counties I represent. I've spoken to the district attorney generals in my counties as well. Even with the bill as amended, it still places the burden on local law enforcement to arrest a federal officer if they're in the state of Tennessee to enforce a federal law, that is constitutional or not. Their job is not to determine the constitutionality of a bill. Their job is to enforce the law. They object to this bill because it places them in the unenviable position from the sheriff's department standpoint of arresting people that they go to work with every day to keep each and every one of us safe. In addition, the district attorney generals are officers of the courts, and they are also under the arm of the attorney general, who has opined that this law is unconstitutional. Therefore, if a district attorney general prosecutes someone under this act, they have lost their immunity from any prosecution or any action against them in a civil court of law, and they therefore place themselves personally liable for their actions. In 1880, in the case of Tennessee versus Davis, which the Attorney General referenced, a federal revenue officer came to the state of Tennessee to bust up a moonshining operation. In the course of making that arrest, there was gunfire and he shot and killed someone. He was arrested by the state of Tennessee. There's a federal statute on the books. It's 28 U.S.C. 1442, and it allows a federal officer who is in the course and scope of his employment who's arrested to remove his case to federal court. That is still good law. That case is still on the books, and that statute is still on the books. With that in mind, if we pass this law, we are absent the constitutionality of it. We are passing a futile act because any officer, if anyone does get arrested under this act, they will immediately remove the case to federal court. They won't be tried in the state of Tennessee. They'll be tried in federal courts in Tennessee. And therefore, we have spent all of this time on an issue that will not resolve anything. that this is merely, in my opinion, a symbolic act. Now, I agree with the symbolism of the act because we must protect our Second Amendment rights. But we must do so within the proper procedures that we've all passed and agreed to in our glorious Constitution. And for that matter, I will not be supporting the bill. Thank you, Mr. Chairman.
Thank you. Mr. Maher, please take the vote.
Senator Bell. Votes aye. Senator Campfield.
I object. I ask for a call of the clerk to see if the call for the question was ever made. And who seconded the motion?
Senator Campfield, the chairman has ruled that there was no one else who wanted to speak. The last two people who were, and I'm not going to get into an argument over this. The order was Senator Stevens to close, and now you are charged to vote aye, no, or abstain.
I would ask a call for the clerk to see if the question was called.
Aye, no, or abstain.
I object, but call.
Okay. Next member of the committee, please.
Senator Finney. No. Votes no. Senator Ford. Senator Gardenhire. Yeah. Votes aye. Senator Green. Aye. Votes aye. Senator Overby. No. Votes no. Senator Stevens. No. Votes no. Chairman Kelsey.
No.
Mr. Chairman, we have 3 ayes, 4 noes, and 1 abstention.
3 ayes, 4 noes. The bill fails. Senator Campfield, how do you vote?
I voted yes, but objected to the motion.
The vote is 4 ayes, 4 noes. The bill stays in committee.
Mr. Chairman, could I say one more thing? I think that even though we didn't get the votes in committee today, it's still alive. But regardless of that, this has caused the best debate we've ever had on the Constitution. And so even if this bill never flies, it's something we need to continue so that we as legislators know what the Constitution entitles us to do, to know what our freedoms are in this country, because they're being taken away very quickly.
Thank you, Senator Beers, and I agree with you 100%. Senator Overby has moved to adjourn without objection, so ordered.